Alright, Travis Wayne Goodsell. Here it is, what the 20 of you viewers of mine have been waiting for. The motion for summary of judgment for the plaintiff. This will go over the whole case as it, I guess, can be compared to a closing statement, as this is what's typically done in a court case where the parties give their closing remarks before the judgment by the judge or the jury, and such. Summary judgment motion is requested here. Rule 56 is the summary judgment for the plaintiff under the following rules, and the reasons is what I'm going to read to you. This, if you aren't familiar, this is the defendant here is the Church of Jesus Christ of Latter-day Saints. They're a corporation of the president, the business entity of the religion, and this should explain the background as I sum up for the summary judgment motion. I put in Rule 27 for motions having to do with A3A, time to file, indicating that all motions are to be responded within 10 days after service of the motion. So that gives you a background. The plaintiff filed motion for recusal 10 January 2020 for Judges First and Waddups, and any and all federal judges compromised by the defendant. In accordance to Rule 27, the federal judge's response time was at midnight the 20th of January 2020. Due to the holiday weekend, the judge's filing needed to be by midnight of the 17th of January 2020. As of the filing of this motion, the 21st of January 2020, the judges have failed to respond. Accordingly, the refusal to respond is understood as concession to the motion. There's one bombshell that I promised. The plaintiff reminds the court that Judge First gave order for the plaintiff to amend his complaint within 30 days, which also included a federal holiday in the final week of the 30 days, and even had day 30 be on a Sunday. The plaintiff still managed to respond to the order within the ordered time. The motion for recusal provided evidence that the federal judges acted as agents, as the plaintiff termed in his complaint, or as associates, as termed for criminal organizations, in creating a delay of the plaintiff's case so as to allow the defendant to obstruct justice by the covering up of financial documentation of payments of services rendered to Nancy B. Cohn for her involvement in the plaintiff's 2008 case. The motion for recusal also contained evidence of judicial misconduct by federal judges Waddups and First. Outline and timeline were given of the compromised position of the federal judges and all others in the Utah federal court. All others refers generally, but specifically to both Judges Kimball and Benson, who are still employed after their involvement in 2-6 CV 00371, in which the plaintiff attempted and failed to retrieve his children from being taken to Canada in 1997. The defendant's involvement, along with government officials, with the plaintiff's children's abduction and financial punishment of the plaintiff led to the compromised protection of the defendant by Judges Kimball and Benson, as Judge Benson denied the plaintiff any future petitioning. This led to further attacks by the defendant's agents in Utah government against the plaintiff, resulting in the above-mentioned case in 2008. Utah case number 081906452FS. From discovery, the defendant ordered the plaintiff's prosecution and disappearance without a trial due to the plaintiff's submissions of his Paleo-Hebrew research in as early as 1998, as the defendant blacklisted the plaintiff in the defendant's troublemaker files, number 36434. Judges Kimball and Benson, therefore, were indirectly protecting the defendant from the public knowing and learning about the plaintiff's decipherment and discoveries, as they were directly protecting the defendant from guilt in the plaintiff's children's abduction, allowing the Utah Attorney General, Mark Shurtleff, to swoop in for the finishing attacks against the plaintiff. All the plaintiff wanted was to live a life with his children, even if their mother wanted nothing to do with the plaintiff. And for that right, the defendant and the state of Utah, under orders of the defendant, turned the plaintiff's life into a living hell with neglect, punishments, both physical and financial, with torture, bullying, false arrest, drugging, and attempted murder. And for what? Because the plaintiff pursued an education in the scientific field of ancient Middle Eastern languages, inspired by being born and raised in the religious organization of the defendant. With the plaintiff's release in 2014, he resumed his research and has succeeded in publishing his work. As a result, the defendant's agents again resumed their attacks and punishments on the plaintiff to suppress his work and disappear the plaintiff again, and for good. In light of the historical facts of the treatment of the plaintiff by the defendant and agents for the defendant, the plaintiff filed a motion for recusal for Judges First and Waddups and any and all others compromised by the defendant. The plaintiff provided a second motion for service of process on 26 December 2019, in which the plaintiff informed the court of the above actions by the defendant that occurred after Judge First's hearing on 1 November 2019, where she was notified of the defendant's payments for services rendered. See, this is why I'm doing this, is so I can make corrections. I need to put by the plaintiff after she was notified by the plaintiff. So bear with me as I make the change. Notified. Okay. Hearing on 1 November 2019, where she was notified by the plaintiff of the defendant's payments for services rendered. Control thing is in the way. Judge First subsequently refused to order the motion. By acting impartially in refusing to order motion for service of process, Judge First acted in lieu of defense counsel. Bombshell number 3. And accepted the motion for service of process on the defense counsel's behalf. By not responding to the motion for recusal, Judge First and Judge Waddups concede to the motion and concede to acting on behalf of defense counsel. The plaintiff was planning to motion for dismissal of defense counsel on the same and similar grounds in the plaintiff's motion for recusal. See, there's the ace that I had up my sleeve, ready to be played if the service for process would have been ordered. Plaintiff was planning a motion for dismissal of defense counsel on the same and similar grounds in the plaintiff's motion for recusal, and recommend referral to the Utah State Bar for investigation into potential disbarment. Judges Furse and Waddups, acting on behalf of the defense counsel, appears to make such motion for the actual defense counsel unnecessary at this time. The plaintiff, even though I'm wording this in a serious, documented manner, there's a lot of tongue-in-cheek here. The plaintiff reminds the court of the charges against the defendant, which have been conceded to by the judges in acting on behalf of the defense counsel. See where this is leading? See how this works? RICO Act, U.S. Code 1961, Section 4, 10 counts. U.S. Code 2381, treason, 5 counts. U.S. Code 2441, war crimes, 2 counts. RICO Act, U.S. Code 1961, 11 counts. U.S. Code 7, definition of marriage and spouse, 2 counts. U.S. Code 242, deprivation of rights under color of law, 8 counts. U.S. Code 247, damage to religious property, obstruction of persons in the free exercise of religious beliefs, 4 counts. U.S. Code 249, Hate Crimes Act, 4 counts. If this were a criminal case, this would be the death penalty that the judges conceded to. But unfortunately, it's a civil case, and they don't allow criminal prosecution here. They only allow for a request for relief in the form of money damages. By concession to the motion for recusal, and by acting as defense counsel, Judge Furse also stipulates concession to the plaintiff's case and to the plaintiff's request for relief, for which she herself stipulated in the hearing on 1 November 2019. So here we go. Plaintiff's request for relief being either transfer of ownership, minus the debts and settlements owed of the corporation of the President of the Church of Jesus Christ of Latter-day Saints, or an award of all the defendant's monies and sales of assets estimated in the hundreds of billions, to be paid immediately and in full to the plaintiff. Due to the above reasons, I submit this motion for summary judgment for the plaintiff. As a reminder, Rule 27 orders all motions be responded to within 10 days of the submission. Response date is therefore 31st January 2020, before midnight. Failure of acting defense counsel to respond to this motion, though constituting another concession, does not resolve the case. The plaintiff requests the order in writing and for the public record. See what I did there? As another matter of related business, the plaintiff includes a formal complaint against the clerk of the court, D. Mark Jones. Filing in the beginning occurred within the same day and would show up on the online docket within an hour after posting. However, the docket shows that the second motion for service of process was not filed until the next morning on the 27th December 2019 at 7:42 a.m. They don't open until 8:30. And then, with the motion for recusal, a clerical error dates the filing on Monday, the 13th of January 2020 at 8:19 a.m., when the plaintiff kept record that it was actually filed on Tuesday, the 14th. The plaintiff does not want the clerk to also be compromised by the defendant and likewise commit federal felony crimes on behalf of the defendant. So you understand the bombshells that I put in this? You see how they're not acting impartially towards my case, is instead acting as defense counsel? And since they are acting as defense counsel, they did accept the complaint as the motion of service on behalf of the church's actual defense counsel. Thus, they are the acting defense counsel. And thus, they are the ones arguing the case as well as judging the case. So by failing to respond, they've conceded, which means they say, yeah, okay, you're right, which means they conceded to the whole case. And as a result, I won. And so if those of you who are saying you're a lunatic, Travis, you don't know what you're talking about, this isn't how it works. Yes, it is exactly how it works. This is how you expose corruption in government. They have rules designated specifically so that they remain impartial. Because if they're compromised, it will be exploited by either of the parties. And the judge goes down in flames. Judge already is going down in flames. She got fired. And so that's why I'm hoping that she's doing this on purpose, hoping that I would be smart enough to figure this part out. So, all right. There you have it. And so I'm already on my way to drop this off. So hopefully the clerk will respond better this time and file it today. Within an hour it should show up online after they file it. So we'll see.